These two gentlemen have been gracious enough to come join us today and talk about issues that face the real estate profession, and in particular appraisers. So we're very thankful for them donating their time to be here. So let's just get right in. I've got some questions for you. I think our viewers will have some questions for you as well. But I'm going to just kind of let you start the program however you see fit. Obviously, the big question I think for most folks is what's going on with appraisers from a legal aspect. Why are appraisers continuing to get in trouble, and what do those troubles consist of? And maybe before we're done, we'll talk about some actual cases, how they've transpired, and what happened as a consequence. So, Peter, I'm going to pick on you first, if you don't mind. Just kind of let us know what the hot topics are in the world of appraising right now with potential litigation issues.
I'm nervous to say it. It gets said a lot, but until recently, I have been dealing with a lot of bias-related cases. There aren't as many cases in court as appraisers might fear, and this is something that Craig and I talk about quite a bit, but there are many active matters before HUD, so investigations of alleged discrimination under the Fair Housing Act. And HUD doesn't publish numbers on those exactly, but there are certainly more than 200, probably around 300 or so. And so, yeah, things are pretty calm for appraisers in general, as far as cases, about negligence and that kind of thing. I don't think there are as many cases right now alleging negligence, like you overappraised my property and our bank loaned too much money. I don't see that many types of those claims right now. They still happen, sure, but not as many as we got some years ago after prices plummeted in the last big price decline. So it was until recently the bias type of cases that were keeping me busy as far as cases and investigations. I keep talking in the past tense though, Brian, because I want to let you know that I do have a new job.
Sure.
I'm no longer in private law practice. I'm the general counsel of a commercial appraisal firm called BBG. So that's why I was talking in the past tense. I'm not actively handling those kinds of cases anymore.
Sure. And congratulations on that job, Peter. You're still teaching. You're doing some stuff with us, and we're glad that you continue to do that. And we'll get into it. But I hope you write another book soon. This is Peter's book, and he's not paying me to say this, but it's a great book. It's called Risk Management for Real Estate Appraisers and Appraisal Firms. If you don't have that, you should. Peter, I'm waiting for mine to be autographed at some point. Okay. It's still kind of blank right there. But guys, jump out and get the book. It's got a lot of great information. And actually, there's some things in this book that I actually put in every one of my appraisal reports. So I encourage folks to get that. And we'll talk about briefly some of the new stuff on the horizon. That's why I say maybe you're going to need another book or an update. Craig, so you are still active in the space. Kind of echo or give us a little add on to what Peter said. He said 200, maybe up to 300 cases now. Have you seen a slowdown on the number of filings on the biased types of complaints, or are they still coming in strong?
I think I would say I've seen a slowdown on the filing, though I haven't seen it come to a stop. There are still new filings. In fact, I just this week saw a newly filed allegation of one. So it's not over. It's not done by any stretch of the imagination. There is one active HUD matter that is now proceeding into the hearing phase, into a litigation posture. So that's sort of a new development on that level. I largely echo what Peter has said. In the overall claims environment, we're not seeing as much active litigation right now as we have in years past. What I would suggest that I'm seeing more of right now, and it's a minor uptick, I would say, is on the state level, on the regulatory level. I do think we are seeing some more activity in the license complaints, and that's largely still driven by complaints being submitted by Fannie and now Freddie as well. The past several years of the licensing environment has been largely, and kind of number one with a bullet on the list, it's been Fannie Mae generated complaints subject to their internal auditing process. They seem to have evolved into a separate phase of that too, where um, the initial complaints coming in on the Fannie Mae side were largely identifying some substantive issues with the reports. That seems to have now evolved into also addressing bias and discrimination concerns, fair housing concerns. So, use of language, particular words of gentrification or other subjective descriptors. Um, Freddie Mac has now also begun submitting complaints to the various states as well in somewhat that same manner. So I would say the hot button item on the licensing side is probably those kinds of complaints, and the states trying to figure out what to do with it. And there really is not consistency across the states for how to process that. Some states will process that solely as their appraisal board or appraisal regulator. Some state licensing regulators are working in concert with the Attorney General's office or the Human Rights Commission in a given state, or someone who's more suited to address fair housing concerns. But just because of the nature of the regulatory landscape, there's inconsistency in that application because every state has their own flavor to it.
You know, you're referencing Fannie and Freddie, and I just want some clarity on it. If you know, you may or may not know, and Peter, certainly jump in if you want to opine. My understanding historically has been that when Fannie sends these referrals over, they're not, I'm sure there's exceptions, but in the general tense, they're just sending them over as a referral, not necessarily a formal complaint. It's like, here, regulatory agencies, here's something we see that you might want to see, and take it upon yourself whether or not you actually want to make it a formal complaint. And at that point, the regulatory authority would actually be making the complaint. Or is that the same pattern that you're seeing today? Or are you, and I know some states, when they get it, they automatically say, okay, well, Fannie Mae filed a complaint, right? But the intent was, it's just a referral. And then the state agency board regulatory authority can make a determination. Are you seeing that Fannie is actually filing complaints, or are they, like I'm talking about, more of a referral, and then it's up to the board how they proceed?
Well, what I've seen is what you described, Brian, like, we want to make you aware of this, basically, letter. And I think that most states, and I'm actually on the appraiser board here in Montana, most states, or I can't say most, many states will not treat that as a complaint, doesn't open up a complaint file, because many states have requirements for complaints that it has to be signed by a person. In some states, it has to be signed under penalty of perjury. So yes, some of what you see filed with the states aren't technically complaints, and in those states, they don't get investigated as complaints. But then beyond that, like, the nature of what's in some of those referrals, like I've seen one that said the appraiser inappropriately remarked that the property was adequately served by fire protection. That was here in Montana. That's really relevant here in Montana, though. And it's, what's the state to do with that? That, in my view, Fannie Mae, in saying something like that, they're expressing a preference that an appraiser not use words like that, because it could potentially, in context, maybe be evidence of bias or lead to some kind of bias. But that's a really ephemeral thing for a state board to try to grab into and start investigating. So I haven't seen a lot of interest in the states where I've seen these kinds of complaints go in pursuing that kind of an investigation over something like that.
Okay. All right. So we have some questions coming in, and we'll get to those in just a minute. And I encourage you, if you're watching and you have a question, please jump in with that. We want your questions. Outside of the bias, what are you seeing as some of the common accusations that appraisers are failing to comply, or maybe it's not really a valid complaint at all. It's a complaint that has no merit, right? So kind of a two-part question. How many regulatory complaints do you see that are failing to proceed based on lack of merit? And then how many are you seeing that do proceed, and what is the basis of those complaints that's tangible that the board can take action on?
Well, I
Craig?
think on that level, I think the states at present, and again, it's not uniform, it's not every state, but I think the states at present are perhaps better situated and better equipped to address their incoming caseload than they have been in a long time. I mean, for purposes of context, when I was working for the state as a prosecutor, we were getting north of 400 unique complaints a year. When I was speaking to one of the investigators here a couple of weeks back, they have 4 complaints in investigations right now, with multiple investigators and multiple attorneys. Again, not every state is as flush with staffing, but for the states themselves, their intake has dropped significantly. And with that, that allows them to actually give more care and consideration to the cases that are brought before them. I think right now, overall, the states are doing a fairly good job of separating the wheat from the chaff. And if something really actually has some hair on it, they'll move it through the process and it'll get addressed via conference or hearing where necessary. But at least if what I've been observing over the past year and a half is the states are doing a better job of identifying the complaints that don't really have merit, and they're addressing them sooner. And and really they're taking the spotlight off the appraiser in that case. I mean, if you think going through the process is bad, so is waiting 3.5 years to see if you're still a part of that process. And talk about causing heartburn for appraisers. I can't tell you how many times I've gotten return calls over the years going, "Hey, is my case still open? Do you know? Am I still subject to the potential discipline?" The good news is it seems that the low-hanging fruit, the more easily correctable remedial concerns, and just generally the stuff without merit at all is being addressed and closed out much quicker, and letting people get back to their lives and go out and make some money and be a better appraiser and move on.
Do you have any insight into what percentage of appraisal complaints that come in? And Peter, you might know too, serving on the board currently, if 100 complaints came in, how many are dismissed and how many are proceeding with investigative action?
Well, my experience has always been that a majority, I think a majority of complaints filed to states don't result in actual discipline of the appraiser. For many years, I worked at LIA, the E&O provider, and those were our statistics, and we had hundreds of complaints, and I don't see any evidence that has changed. I think it's like Craig was saying, that the states actually do a pretty good job of not pursuing just the homeowner who complains for whatever reason. This value was too low. The appraiser got it wrong. I didn't get my refinance. So I think the majority don't result in actual discipline of the appraiser.
That's refreshing to hear. I mean, that to me, that sounds like the majority of appraisers are doing pretty good. They're doing a pretty good job. If the majority of the complaints that come in are dismissed, or maybe there's a letter of warning or something along that line, that's refreshing news, and I'm pleased to hear that. And I'm sure the viewers and listeners are as well. Peter, you put something on a social media post not long ago, and I'd like to ask you about it. This is from back in, and just so folks know, This is not rehearsed. Peter, do you have any idea what I'm about to, what post I'm about to ask
Well,
you about?
I'm nervous about where you're getting into because until recently, the only social media I participated in, and it's not really social, was
Mhm.
LinkedIn. So you
Mhm.
might be talking about LinkedIn, but very recently, I reactivated myself on Facebook, and I made a mistake there when I did that. I announced to all my new friends on Facebook that I had just gotten married, and that caused a lot of confusion.
What'd your
including-
wife of several years think about that?
Yeah, my wife of 30 plus years, and my mother was confused too. So, but other people were congratulating me. So,
Well, he's an attorney. He figured out how to do it. I don't know. I don't know. He's got 2 wives now. Okay, Peter does not have 2 wives. All right, let's
Yeah.
get that. Let's put that on the record. No, nothing like that.
okay.
And it's not my style to try and trick a guest or catch them in anything. So hopefully this will be very easy for you. But this is a post I think back in June or July. And I'm just going to read a little bit of it, and then I'd like for you to tell maybe the bigger story if you don't mind. So, Peter posted this. It says, "Appraiser independence question: Can a borrower sue a lender for failing to report use bet violations to a state appraiser board?" A federal court said the answer is yes in a decision reached earlier this month. In this case, the plaintiff borrower sued a credit union for failing to report a variety of use bet issues to the state when the appraiser reused an earlier report performed for a different lender on a different borrower's loan. The borrowers contended that the credit union's failure violated the mandatory reporting requirements of lenders and other parties in the appraisal independence requirements of TILA, Truth in Lending Act, I assume is what that stands for. We got one right. Here's how the court ruled. Plaintiffs have adequately alleged that the credit union violated Truth in Lending by failing to report the appraiser defendants for violating USPEP standards that may be entitled to statutory award damage. Of course, there's a lot more of the actual case, including the details of the recycled appraisal report. The credit union told the borrowers to move on. They didn't move on. They filed a lawsuit. Full story and copy, click here. So 2 things. Number 1, you need to connect with Peter on LinkedIn because he puts this kind of stuff on there and it's very, very valuable. Go ahead and connect with Craig too. He's on there. Connect with me on there. I'm on there too. But Peter,
anything nearly as interesting. No. So, I mean, look, I open in the mornings. I scroll to Peter's page just so I know what's going on. All right.
There you go. So Peter, talk about this. I mean, what I get out of this is don't clone an old report and use it in a future assignment.
Mhm.
That's my takeaway. But give us a little bit more details on this case.
Yeah.
And if you know what ultimately happened, did the appraiser get sued and have to pay damages, or what ended up happening?
Well, the case is still open.
Okay.
So
Okay.
it's a federal court case in your area of the country, Tennessee.
Okay.
And so we don't know the conclusion fully yet. But in that article, I was focused on this issue of the credit union because the credit union it found out in the process what this appraiser had done. He had previously appraised this same property for a different lender for the then current owner of the property. The owner was refinancing the property to get some money out to finish some renovations. So the appraiser did that assignment for that a bank lender, and then that property owner sells the property, finishes the renovations, and it's only like 5 weeks later where the appraiser gets another assignment to go appraise that property again, but this time for a credit union lending money to the would-be borrower and to the purchaser, and so the appraiser probably thought that, okay, this is going to be easy, and reused all the photos from that prior appraisal. You can put the appraisals side by side together, and you'll see like almost every word, every photo, except for lender names, borrower names, are identical between the 2 appraisals, and that was a big issue for this appraisal because the appraiser had not actually gone out and re-inspected for the new assignment, but but all those renovations had been completed. So
Mm.
the appraisal 5 weeks earlier said, oh, we've got here's a lot of stuff in progress at the home. Renovations haven't been completed. Well, when that purchaser was buying the home, everything had been completed.
Oh,
So the appraisal did not come in with a value that was sufficient for these purchasers to get their loan. They were unhappy about that. They raised that with the credit union. And the purchasers found out that, oh, this was all based on the prior appraisal, brought that to the credit union's attention. And the credit union basically told the appraiser, we're fine here. Just change the date in your appraisal to match up with your earlier inspection. Never mind all these USPAP problems that we've got going on. You didn't disclose that you'd appraised the property before. You reused work product for a different lender. A lot of issues going on there.
Do you know, did they just use the same comps, same adjustments, and same value?
Yes, except for one property that had, I think, shifted from a listing to sold. So there was one difference maybe out of the 6 comps, but all the other adjustments and the value were identical between the two things. So the credit union actually turned down the purchaser's loan. I think that the purchaser went on to get a loan from a different source, but that higher interest rate, delays, money out of pocket. And so the borrower sued the lender, the credit union, but also sued the appraiser for negligence. And so there's a lot more to the story. I was focused in that LinkedIn post because one of the borrower's claims by their pretty smart lawyer, I think, was, oh, we have a violation of the Truth in Lending Act in that the credit union failed to report these USPAP violations to the state. And that's because lenders have a mandatory reporting obligation under the law. And this was entirely new claim. Like, can a borrower sue a lender for not reporting an appraiser to a state board? And the federal court came back, yes, you can sue. And so there's statutory damages there of, whatever they are. I can't remember the exact amounts, but statutory damages, like a low amount, maybe it's $400 or $1,000 per violation. So, but the borrower can actually sue the lender for doing that, for failing to do that rather. Now, the borrower had other claims against the credit union. Oh, you were negligent in not giving me this loan, that kind of stuff. Well, those claims were dismissed. So it was just this technical claim that remained. But against the appraiser, they had kind of similar claims, and some of the claims against the appraisers or the appraiser were dismissed. Basically, the appraiser didn't know a duty, or the appraiser the borrower didn't rely on that appraiser's report. A lot of the claims against the appraiser were dismissed too, but one survived. So I think the appraiser and the credit union are still fighting this. It's not a big case anymore. But it's a story about how to get yourself. Now, most appraisers are never going to do what is alleged in this case.
Well, maybe not that grievous, but many appraisers will take a report and try and recycle it and use it again. And I've always warned that's I know me. I've met me. I'll forget to change something. It had a patio. No, they've just built a beautiful big deck on the back, and oops, I forgot to change patio to deck, which isn't intentional, but still, nonetheless, I made an error, right? So if I just have a clean slate, I know I'm not going to make that mistake. But just curious on that, has the credit union taken action against the appraiser?
I don't see any. I don't see any evidence that the credit union actually made a claim against the appraiser.
But I suppose they could. I guess they could.
The damages to the credit union would be small. Like, the credit union didn't actually make the loan based on that appraisal or whatever. The credit union might plausibly say, oh, you got us into a heap of trouble. And we've had to spend money on attorney's fees defending ourselves because you did this. But I think that would be a hard claim here for the credit union to make. So, an interesting case, but it's for credit unions and similar lenders. It's really about compliance. Like, gee, are there going to be more borrowers? Could there possibly be 20 borrowers who band together and sue our lending organization for not complying with this legal responsibility to actually file complaints against appraisers? That's a little scary for lenders and appraisers.
Well,
Good
and
point.
inviting rote speculation here, I recognize I'm doing that, so maybe we don't want to tread too far down that path. But, you know, Peter, I'm interested in your thoughts. I know I have mine. What are the implications of even just this claim surviving motion to dismiss as far as the liability environment for appraisers? Are bank counsel sitting around now seeing that the claim has survived going, we'd better ramp up what we are reporting to regulators lest we find ourselves in that chair as well? Do we think we're going to see any sort of a bounce in regulatory actions submitted by lenders going, Dodd-Frank said so, and apparently we could be held liable, so we don't know for sure, but we're turning it in?
I think that like compliance, there are these organizations that advise lenders on compliance, and they follow these kinds of cases too. And I think that some of those compliance organizations will be telling credit unions, hey, you need to do this. So yeah, I think we could see an uptick of compliance with this obligation, so more complaints. And then I've been looking in the chat, and I just saw a relevant question come up about this.
Yeah, there's a few I wanted to get to there.
So, so when I saw reconsideration of value go by, because there's also, Craig, I think you're more attuned to the new reconsideration of value requirements, but there's also a reporting obligation in there, isn't there, of lenders. So I think we could also maybe see more complaints as a result of the new reconsideration of value processes that are being put in place. But then someone else had asked this other question, which I get a version of these questions quite often in the presentations I give. But do we as appraisers have a requirement to report USPAP violations? So you're out there, you're doing a review, or you see someone, I think the person gave an example of a divorce case, and the other appraiser used a lending form in the divorce. And so the question was, do I, on the other side of the case, have a duty to report that? And I don't know of any duty under any USPAP. Certainly there's no mention of this having to report another appraiser, but I don't know of any duty under any state appraiser licensing law where, you see something that another appraiser has done, you have to report it. I don't know of any obligation like that. And I think you're
correct. Yeah, I'm right there with you on that one. I love that example because it's the one that still comes up. And yes, I think, Peter, I think you would echo this as well, but believe it or not, we still have 1004 forms that land on our desk that were for use in an estate or a divorce matter. And when one of those does pop up, you are booking yourself a one-way ticket to meet with your state regulator. But that doesn't mean that it's going to be a reported offense of any kind. And, the defense, the counterpoint to that from the appraiser who's utilizing that form is frequently, well, that's what the judge wanted. The judge took it anyway. That may be true, but we're fond of saying USPAP does not turn on or off. It's on. It's on all the time, and that's going to be a problem. So it's a great example to refer to, but to echo the question, and Peter, you're exactly right. I'm unaware of any regulatory requirement. Certainly USPAP does not impose one. The appraiser need not report another appraiser for actual or perceived USPAP violations, though, and I don't want to throw gasoline on the fire, but I commonly hear from appraisers, well, I can't believe I'm facing a complaint in front of the board. I've been doing this for X years, and can you believe how many terrible appraisals I've seen, and they never have any problems? Well, is it because those aren't getting to the board? I mean,
they got lucky. They've been lucky for 20 years.
Right.
Here's the thing. And guys, we got to take a break in just a second. And we are going to go ahead and start getting to some of these questions because some of the questions are relevant to what's coming, the conversation we're having right now. But on that one, and Don, thank you, Donald, for your question on that. What if Donald called the appraiser? Now, the appraiser may say, go to heck and hang up on him. But there would be nothing wrong with Donald saying, hey, we were in court against each other last week, and I'm not trying to be a jerk here. I'm actually trying to be helpful. You know, the 1004 form, if you look at it, has a pre-printed section saying the intended use is for a mortgage finance transaction only. We were in court for a divorce. And by the way, Standard Rule 2.2a, Roman numeral, I think it's 12 now, talks about your highest and best use. And, you know, it wasn't in there. I'm just, you know, I know it's none of my business. I'm just trying to help out a fellow appraiser. What do you guys think about that? I mean, we don't like to be criticized by anybody, but anything wrong with doing that?
I would say, yeah, do it. It's a favor to it's a favor to your colleague, and it's absolutely correct. And I have seen appraisers disciplined by states because they use the 1004 in court.
Right.
I would say yes. Now, in the middle of the case, I think Donald F. there with his chat question about that situation. It was a divorce case, and I think he should let the counsel that he's working for, of course, know, you know, hey, there's this issue here. And because, as Craig said, though, many courts will like, I like this form. You know, I like this is this is the appraisal that was done, form that was used for my house. So it'll fly right by. But there are other courts that would go look and have looked at that language. An appraiser acting as an expert, and they start reading mortgage lender. We're not mortgage lenders here in court. These certifications, I have actually seen courts throw out the supposed expert's valuation because they put it on that kind of a form.
Well,
and so the statements.
The form says borrower.
Yeah.
Borrower. Who's the borrower? This is a divorce case. There is no borrower. Hey, hey, Jim Morrison, do we have a sponsor we need to shout out to?
Absolutely. We really appreciate the Appraisal Institute for sponsoring this webinar and helping us get all this information to you. We have a quick audio clip from them. Let me play it right now.
Are you wondering how property insurance is changing in the wake of climate events and natural disasters? Need a primer on appraising religious properties? Want to learn how tech tools can streamline your workload? The Appraisal Institute's Trending Topics Thursdays webinar series is designed to help appraisers everywhere do their best work by keeping a pulse on industry trends, tools, and relevant skills. Join the Appraisal Institute as a member to gain access to timely content featuring leading experts, or join us live for the next webinar. Live sessions are free to attend for members and non-members alike. Visit appraisalinstitute.org to explore the free webinar series.
All right, guys. Thank you, Craig. Thank you, Jim Morrison. Let's get back into this. And I want to go ahead and start asking you guys some of these questions because, you know, I hate it when I'm watching something and we run out of time. We can't ask any questions. And granted, you know, if 400 questions come in within an hour, we can't answer that many either. But we certainly try to answer as many as we can because that's why we're bringing these to you live and in the format that you can ask questions. So let's get into some of these. So a couple of I'm going out of order because some of these were very relevant to the conversation we just had. And it says the appraiser must disclose the prior work ? And thank you, Martin. But Peter mentioned that he didn't disclose the prior service. So that was probably another one of the issues. Nikki says, I guess the ethics rule of USPAP was overlooked. Yes, Nikki, I would agree with you there. So Craig asked a question and he says, are you aware of the anti-appraiser advertising by the NFHA with financial backing by HUD at multiple international airports, billboards, and magazines?
Oh, yeah. As a proud subscriber to Men's Health magazine, just kidding. I'm not actually sure who's still subscribing to that. But no, I am aware. There are the billboards, there are magazine ads. There's quite a bit of activity in that space right now. There is a full-blown ad campaign at the moment that is charitably put, promoting awareness of the potential for bias and discrimination in valuation. And it appears to be at the moment a well-funded ad campaign. We're watching that, and it may well yet lead to additional filings. There may be more claims coming as a basis of that, as that awareness is raised. But it's certainly a topic of conversation right now. I'm not sure really what to do with it or what to do about it, but the ads are out there and they are in circulation. So it very well may inspire some additional regulatory actions to be filed.
Yeah. Related to that, I've seen clusters of HUD complaints within small neighborhoods. So this is a top beyond ads and billboards. It's a topic of conversation, like between neighbors. And so there's one neighborhood in smallish neighborhood in the Los Angeles area, very specific neighborhood. I've seen 4 complaints in that one neighborhood by different borrowers. Yeah.
Wow. So they're definitely having coffee and chatting about what's going on. So Bill says, can a borrower sue an appraiser for failing to respond to a reconsideration of value request? Thoughts on that?
To me, that would be a stretched claim to specifically sue the appraiser for not responding to ROV request, because when we were talking about that credit union case, we were actually talking about the law, Dodd-Frank mandatory reporting obligation. So there's the law. There's not literally a law saying that appraisers have to respond to ROVs. Craig can differ with me, but it would be a stretch. I mean, I think it could be part of the story of a claim against an appraiser, like the value of the appraisal for the value in the appraisal for my refinance came in low. The appraiser made these errors, and when I tried to bring the errors to the attention of the appraiser didn't respond to my reconsideration of value. It would be part of the story, I think, if I were a borrower bringing that type of claim, but I don't think it would be a specific legal claim.
Yeah, and I agree with that. I'm not sure that the borrower can get to the appraiser for a failure to respond, though, and this touches back on something we had discussed a little bit earlier. A failure to respond to an ROV by the appraiser is likely to create a heap of trouble, because at that point, the lender, the appraisal management company, is almost certainly going to make a report to the regulators under the framework of the ROV updates at that point. And so it's still going to create a problem. I'm just not sure that the borrower can get to the appraiser on the liability chain with that question.
Yeah. So Craig, I saw something like a headline for a program that you're doing about reconsiderations of value. And the headline was, I think, how this may reduce risk for appraisers in a certain way. Was that part of it?
It is. And I think that's the other side of this coin. I recently did a podcast webinar with Tim Anderson. We spent probably about an hour talking about ROVs. If you all will indulge me for a moment, I'm going to give a shameless plug here. For the folks that are watching live, it's not too late right now to book your plane ticket tomorrow to Appraisal Summit, where I will be on the ROV panel at Summit discussing this same idea. And the evolution of this ROV process is, believe it or not, and I understand for a lot of the appraisers out there, it's not, but for believe it or not, the intent of refining and sort of raising awareness again of the ROV process really is, it's intended to try to turn the temperature down a little bit and reduce liability and reduce risk. So I was with a number of the GSEs and the alphabet agencies at an NAR summit on valuation 4 or 5 months ago. And the GSEs came in and really did their first rollout presentation on the updates to the ROV process. Everybody should be aware that ROV is not new. It's been there. It has been there for a long time. The question has been, does everybody understand how it works? Is the ROV process really procedurally best constituted to help solve the problems it faces? And I think a reflection on that over the last several years has revealed that no, there's some cleanup here. The thought process behind the latest rollout of ROV update is it's refinance facing. Curiously, it wasn't really transactional facing. It was really refi facing, intended an opportunity for borrowers, if they identify a concern, a flaw, they can raise that concern with their lender, and then the lender, as a gatekeeper, has to vet those concerns to make sure they're legitimate concerns. So it's refined everything to basically there's 3 elements that could give rise to a legitimate ROV, and then that ROV can then be presented back to the appraiser with supplemental information to consider. The idea being, if all of this gets addressed on the front end, then it's much less likely to go through loan closing and get escalated to HUD or CFPB or a state regulator as a bias or discrimination claim. If they can address legitimately raised concerns in real time in the workflow, it's going to help reduce the number of claims. Now, are there actors out there that will try to find loopholes to push an agenda? I'm sure there always are. But the reality of it is I could see it actually reducing the liability, reducing the likelihood of something escalating to a claim if the ROV process is utilized correctly and does actually adhere to the processes they've rolled out.
I agree that, like, when, I've, in my various positions over the years, I've spoken to hundreds of thousands probably of appraisers who are in the middle of an assignment and some information is brought to their attention. And I always would tell that appraiser, if that loan hasn't closed yet and someone's bringing something to your attention, look at it. And because that's your opportunity to, if you need to fix something or address something, if you can do that before that loan closes, that's going to really reduce your risk of some kind of a liability claim later.
So a few things with that. VA has the Tidewater Initiative, and they've had that for a while, and it seems to work for them. What we've incorporated years ago, I have a checklist, and when we go out to a property, we ask the homeowner, hey, will you sit down and fill this out? Instead of them following me around the whole house, right? Typically they say sure, and they sit down, they fill it out. And I have Peter's statement on there about, hey, don't rely on this, right? This is for the bank. Get an appraisal of your own choosing. I have various disclosures on there, but I'm asking questions that you would normally ask. Have you updated or remodeled your kitchen? And if so, what time frame? Have you had the property offered for sale in the last 12 months? But one of the very last questions is, are you aware of any sales you would like for the appraiser to consider? So it's almost like I'm asking for the ROV in advance. I'm not saying I'm going to use them as comparables, but if you tell me some sales that you'd like for me to consider, I will look at those and analyze those and either discount those for whatever reason, or maybe I will use them, right? Fannie Mae's new thing coming, and I did a little teaser on the podcast that'll be out next week on this. Guys, this is coming. All these forms, as you know them, are going away. And I know you've been hearing this for a long, long time, and you're like, it's coming when? It's never coming. It's coming. The train is coming. We see the train coming. We hear it. It's coming. You better get ready. And one of the things, there's several things I like about it. There's a couple things I have a little concern, and I'm going to share one because I want your folks' opinion in just a minute. But one of the things is there's opportunities for appraisers to put sales within the report mechanism. Even if you didn't use them, even if you don't classify them as comps, you could put sales in there and then explain, you're not making adjustments because they're not comparable sales, but you could literally put 3 or 4 sales in there and say, this is why I didn't use these. And so it may help hedge off a potential ROV because, let's face it, the real estate agent's picking what sales for the appraiser to consider. The highest sales they can find, right? So if we address those in advance, maybe that discourages that ROV. Let me get to some of these other questions, and then I do want to ask you guys a question before I let you leave, and the time is going quick. So guys, if you have a question, get it in now. So Scott says, I agree not to clone the report. I think it's smoother in preparing the appraisal and following my own normal process from scratch. Thank you, Scott. Martin says, and we've kind of talked about this, but he says, is failing to report a USPAP violation in itself a USPAP violation? So I assume he's asking of appraisers, because let's all remember that banks don't have to comply with USPAP, right? Only the appraiser is held accountable to USPAP. So is failing to report a USPAP violation in itself a USPAP violation? Was floated in Michigan and failed. Thoughts on that, guys?
Well, I would say no, but I did see that an appraiser also put into the chat, well, I was talking to an investigator at BRIA who told me I needed to report this. So I would be curious about what the California Bureau of Real Estate appraiser investigator told an appraiser out in California about needing to report a different appraiser's USPAP issues. But in general, no.
Yeah,
Craig is saying,
I'm not aware of that. I don't see that obligation that's there. Certainly under USPAP. I know, Peter and I are aware just about every state, and I think Craig in the chat also referenced that up until recently, California attorneys did not have a mandatory duty to report. We've had here in Illinois something called the Himmel case that's been around since the 70s, that it defines a narrow subset of misconduct, but where an attorney becomes aware that another attorney has violated XYZ provisions of the code of conduct, there is a mandatory requirement to report that to the state bar unless otherwise cloaked in privilege. Like a client comes to you and reports, attorney A was doing this and he did the bad thing. Well, if it's an attorney-client privilege statement, I can't breach privilege. But if I become aware of it in another way and I have firsthand personal knowledge that the violation occurred, I would have a mandatory duty to report it, or I may lose my license. Any number of states have that sort of requirement for attorneys. I'm not aware of one that has such a requirement for appraisers.
Yeah.
Douglas is saying a lot of appraising is based on what our peers are doing. So we should be able to talk to our peers just like any other profession. I agree with you, Douglas. Be careful though, as who you identify as your peer, and recognize that you may have peers in certain instances, and those same peers might not be considered peers in other assignments. So, I do commercial and residential, and let's say, Craig's an appraiser and he does industrial, I do industrial. We're both each other's peers. But if Craig's appraising a gold mine, I'm probably not his. I've done a rock quarry. I don't know if that counts, but I'm probably not Craig's peer in that particular assignment because I don't have the experience and the expertise in appraising gold mines. So just keep that in mind. Tamara says, our board tries to remind our appraisers that you must use the correct form. And yes, we will consider it in our discipline. She's in DC, and I'm seeing those billboards on the metro trains as well. Eric, your thoughts on declining assignments of borrower who are a different color than you to minimize the possibility of a lawsuit for racial bias, ?
Can I take that one?
Craig, go.
I have heard from multiple appraisers now a variation of that. It typically has revolved around, well, that's simple then. I'm just not going to accept an assignment in this neighborhood or that neighborhood because of the liability environment. We have created the scenario that we are trying to avoid here by reacting in that way. And I will caution you this, as HUD has become more sophisticated about investigating these things, as regulators have started to identify what information they may seek to determine that activity, one of the things they are looking at are the frequency and the volume of appraisal assignments in a particular geographic area. If you are an appraiser that's out there and now you've just got several gaping holes on the map where you've never taken assignment, that might invite questions that you don't really want to answer if you find yourself under the microscope. I would very much caution against the behavior, And I would caution against making statements of that nature, only because I think that actually increases your risk, your liability concern there.
Mhm.
We don't want to encourage that. Now, is that a byproduct of what's going on? And I think, are we going to see that in practical application? Yeah, unfortunately, I'm pretty sure it's already happening. But that's not the outcome that we want here.
You know, and what's creating this question for me is what Craig just said about, you know, going to a location. So let me ask both of you this question, because I've had appraisers ask me this question, and I'm like, talk to your legal counsel. Well, we've got two smart attorneys on the call right now. So I'm going to share some questions that I've received by practicing appraisers, and I'd like for you to opine if you're willing to. If not, that's okay. One gentleman said, well, I'm only going to appraise in a certain area. It's my business. I'm in charge of my business. I do whatever I want to. And he was talking about like 20 miles from his office. He gets enough work. And I said, you know, I'm not an attorney. You probably need to talk to an attorney. I said, if it were me and I made that decision, I would have a 20-mile circle around my office. And I'd say, I go in any direction. I only go out 20 miles just because that's as far as I want to go, but I'll go in any direction, a circle around my office, right? That's what I said. And then the second part, I've had appraisers specifically say, Brian, I've been asked to go appraise a property in an area and I don't feel safe going there. And my response is, I'm certainly never going to tell you to go, well, too bad, go do it anyway. I'm never going to say go somewhere where you don't feel safe, but you need to talk to an attorney, because I don't know the answer to that question. That hasn't happened to me. I have no history on that. And I don't know what the legal advice would be for someone like that. So if you guys, I know that's a tough question. It's not mine. It's one of my students. How would you advise an appraiser that has that question for you? What would you say to one of the folks watching right now? If they say, I'm scared to go appraise this particular house, what's your answer?
Well, I think my answer for the appraiser would be, if you feel for your safety, I think that's a valid reason not to do an assignment. I'm not going to tell an appraiser that you have to appraise all houses or in all areas of a region. But you could never, the reason for turning down an assignment can never be one of the protected categories: race, religion, national origin, etc. But there is no specific prohibition on declining assignment because you fear for your safety in a certain area of a city. So I wouldn't be telling an appraiser they have to do that.
Yeah, I
Okay.
agree. I think individual personal choice, safety is still priority one. That's a valid concern. And what I would caution against is a pattern of such decisions that becomes a discernible pattern. And if that's the particular idea, you know, where are you deploying that decision? Is it just on the east or the west side of this particular boulevard, or something that becomes more granular and suggests maybe also some introspection is in order? Why is it that I feel this way, and what is the nature of that? That, I think, goes to the bias and cultural competency question, right? I think we should all be inviting those questions about ourselves. But also with that, if you actually then create a discernible pattern of, yeah, these are the 17 assignments that I've turned down, and you can draw concentric rings around that concern, maybe you're best to remove yourself just generally from the area. Because to Brian's earlier question, you know, somebody that takes their office and places it in the middle and draws a ring of whatever radius, sure, why not? I don't see a problem there. Just so long as everything that falls within the circle is fair game, and anything outside the circle is just outside the circle, that's fine. If we start also looking inside the circle and go, I'll go anywhere in the circle, but not there, and I don't like to go there, and I'm not, again, it's the creating a pattern. And the regulators who are looking at this are, in the absence of evidence, in the absence of an idea, in a singular instance that's giving them anything really to work with, digest, understand. They are looking for patterns. So don't create a pattern. Now, that sounds a lot like I'm telling you, here's how you avoid being caught with your bias. It's not what I'm saying. Don't do it.
Right. Right.
But
Yeah.
don't also give anything that looks like you might be doing it, because it's the perception. That's where the fight's occurring. Actual cold, hard facts are very difficult. I was always reluctant to charge ethics violations and standard 1 violations, because a significant component of that requires me to be in the appraiser's head.
Mm-hmm.
I was always eager to charge a standard 2 violation where I had it, because I know what to do with that. That same concept is, it's hard to prove fraud. It's hard to prove intent unless you write, hey, I am criming now, right?
Yeah. Yeah.
But the crazy part is we see it.
Some people do. Yeah. Yeah.
Right. So
Hey,
don't do that, and don't give the whiff of that by your other actions.
we've only got a couple of minutes left. I got a few more questions, and then I want to ask my question regarding a policy change. Although this is just reporting right now, it's a reporting change. I'll say that. David says, should you maintain professional liability insurance after retirement from appraisal work? And if so, how long? Great question, David.
Well, yes, you need to think about staying covered after you retire, but for appraisers who work alone, there's a very easy solution. It just gets a little more complicated if you work in a firm. But the easy solution is that virtually every E&O provider out there has some element of something called retirement tail coverage. And so in many E&O programs, if you've been in that E&O program for a certain number of years, usually it's 3 or 5 years, and you've reached retirement and you are retiring from appraising, you can get that retirement tail coverage for free in many instances. So that means that you would be covered for claims that might be filed against you for the rest of your life, actually. So you don't even have to think about, oh, how long do I need to buy it? So if you're retiring, you want to have that conversation with your E&O provider about your tail coverage options.
I'm going to rapid fire just a few because I know you guys have we're running out of time, but just a couple more. Donna H., how many appraisers, if called by a peer about an issue, would be less than open to hearing criticism, even if for educational purposes? Donna, you're right. And unfortunately, maybe we need to look in the mirror and rethink that. You know, my business partner, my brother said one time, would you think I'm a jerk if I corrected somebody? And I'm like, what did I do wrong? He's like, well, would you think I'm a jerk? I said, no, I want to learn. If I'm making a mistake, let me know. Donna, don't call me and just call me and say, Brian, you're stupid. That's not helpful. I can't correct that. But if you call me and point out that I made an error, maybe you should provide me some support that I made that error. I'll own it. I'll say, gosh, Donna, you're right. I made an error. And now that's actionable. So how calls that actionable criticism? Not just criticism. Don't call me and say you're stupid and dumb. I can't fix that. Okay. But if you say you made an error here and this is the support I have that you made that error, I can do better. I can make corrective action. And so I think you're right. I think a lot of appraisers would be resistant, but I'm hopeful that more appraisers are becoming more open to taking actionable criticism where they can improve. We all have room for improvement, right? Eric says, when testifying, how much does the judge know? How much should I simplify it? I'd say make it real simple for any judge or jury, especially a jury. They don't know probably anything in the valuation space. And Craig and Peter, what would your answer briefly be on a judge in a case? How knowledgeable are they in the valuation space?
I would suggest being attentive to the judge's knowledge, because there are some judges who know a lot about valuation because they are seeing appraisals day in, day out. But then and for example, even a divorce court judge, they've seen a lot of valuations. So you're not going to have to be explaining fundamental appraisal theory in most cases, to a divorce judge. Other judges, okay, somehow your appraisal is relevant to a criminal situation. Yeah, you might be needing to get into kind of the nuts and bolts, a comparable sales approach and explaining what you did. Yeah.
But running with
Context.
that, I would agree, and I would say, not to be too glib about this, but be prepared to write it in crayon. Your job in that context is to be an effective communicator to the listener. And so Peter's exactly right. Be attentive to your listener and try to meet them where they are receiving your information. Your job is not to hit them with all the really expensive words so that they know how gosh darn smart and qualified you are. You should, if you get the opportunity, get some background on that judge in advance. How often do they hear these kinds of cases? How familiar are they? And you can tailor your presentation of your material to that listener. That's really more important at times than the information you're presenting. As a young prosecutor, I was taught something that I'll edit for public consumption, but it was basically the mind can only absorb what the rear can endure. And if you're talking past your listener and they're all over the place, you've lost them already.
Time to stop.
So as an effective communicator, it's meeting them where they are at to receive your information. And that will vary by judge. It will vary by case. But that's the sense that you're going for, is are you able to identify that and then meet your recipient where they are?
I just testified in a case. I'm not going to say who it was involving because it's an ongoing case. I'm probably going to testify again in spring. But I think I was the only expert witness that constantly, after I received the question, I looked over to the judge and I was speaking to the judge. I might glance back over to the attorney or the attorney I was working for, but almost every answer, I'm looking at the judge and I'm telling the story to the judge. And when I'm doing that, I can see her responses as to whether or not she's understanding what I'm saying or it's going over her head. And now I can pause and back up a little bit and simplify it. But yeah, Will said both guys. I agree wholeheartedly. You don't want to use a lot of technical terms because people don't know what you tell a homeowner they have functional obsolescence. They think they have a disease, for crying out loud. They don't understand that appraisal jargon. Okay. Last question. And I'm going to give a little snippet out, guys, for the new URAR. I've been telling you, it's coming. Hal and I was at Fannie Mae's office in Dallas, just got back. Now I'm going to see Craig out in Vegas in a couple of days. Come on out to Vegas. Craig will be there. I'll be there. Peter, I don't know if you're going to be there this time, but Peter will be there
too, right?
We'll all be there.
We should have recorded this live from
the
sands or wherever.
We'll keep the conversation with the attorneys and the ding dong in Vegas. So come join us. I'm not coming out till Saturday, guys. Oh, tomorrow is Saturday. Good God. Yeah. All right. So let me give you a little snippet. And I'm not breaching any confidentiality or anything. You can find what I'm talking about right now if you go to Fannie Mae's website or you go to Freddie Mac's website. So if you go to either one of those websites and you get the Appendix F, that's the URAR reference guide. It's going to give you lots of material of what you're going to be seeing in the new reporting format. But I'm going to give you one. And guys, there's a lot of things I love. So please don't take this one thing and start crying about it and being all mad about it. But it is a question I have for the two attorneys. Field 4.067, broadband internet availability. Hello. Broadband internet availability. When to include? Always required. Allowable answers, yes or no. Are you with me? Is everybody with me so far?
Yeah.
So you, as the practicing appraiser, are going to confirm whether or not there's broadband internet available for the subject site. You're always required to answer this question, and your choices of answers are yes or no. There's not an unknown, yes or no. High speed, here's the description and additional guidance. Yes means high-speed internet access is available exclusively through a digital subscriber line, fiber optic, or cable. No means high-speed internet access is unavailable or is only available through satellite. Here we go. So wait. I haven't asked you the
Okay.
question. Here's my question. Buddy of mine bought a house several years ago. He's a big IT guy. He works for the hospital. So you can imagine high-speed internet's very, very important, correct? He bought a house. The seller said, yeah, we got broadband. The real estate agent, yeah, we got high speed.
Mm-hmm.
Perfect. He bought the house. He moved in. He called the internet company. I need to connect.
Mm-hmm.
And they said, well, it's in your area, but he's like, but what? I'm an IT guy. I need broadband today. I'm an IT guy. And they said, well, it's on your street, but it's across the street. We're not on your side of the street yet. He said, you don't understand. I need this to do my job. What's it going to cost for me to go ahead and have you come to my street now and get it at my house ASAP? We can do that. How much? $12,000. Here's my question. Obviously, he wasn't happy. Maybe he would have had recourse against the brokerage firm, the real estate agent, maybe the selling brokerage firm, the selling agent. When this becomes effective and the appraiser said yes, because they interviewed the homeowner and said, yeah, it's available. And they said yes. Would there be recourse against the appraiser? And what can we do as practicing appraisers to try to protect ourselves against that potential situation? Peter?
Well, I'm speaking to you from rural Montana, and I'm on Starlink satellite internet.
Perfect.
I've seen cases just like you described also, Brian. There was one in Seattle, $74,000 to get the house hooked up. Was not against an appraiser, was against the agents and brokers. And Craig can, correct my thoughts, but it's a plausible claim against an appraiser. I can see it being made if this is a purchase and the appraisal was for a purchase. And if the borrower can say, I relied specifically on that appraiser's determination. Now, was that reasonable reliance? I don't know. But then the appraiser is going to argue my appraisal report was not for you. I didn't owe you a legal duty. My duty was to my lender, client, and other intended users. Then we're going to get in a fight. There's certification number 23 and in the current form, and that's being carried over pretty much into the new forms.
Despite our better efforts, we didn't get rid of that.
Yeah. So it's a plausible claim. The appraiser is going to say, no, this is not the purpose of my report. And it's not for you, the borrower. They're going to have good defenses in many states, and they may prevail on those. But what else can an appraiser do besides hope that it's defensible? They could cite the source maybe somewhere else in the report for that information. That could take a little heat off the appraiser. I don't know. What are your thoughts, Craig?
No, I think I largely echo your thoughts on that. I think you don't have to squint too hard to see how that could be a claim against an appraiser at that point, because it's now a field that would be, it's a populatable field in the reporting formats. So somebody out there is going to presumably claim reliance on that. Again, not to be a complete shill about all of this, but in reference to certification 23, Peter, do you know, is there some sort of a statement out there that you might be able to also include in the body of your appraisal report to hopefully help curtail and limit the impacts of certification 23? Might such a statement even be located in your book that Brian was showing people earlier, that you can at least try to rein it in some? I don't know that there's a perfect answer, but language to help protect against that. And to your point, I think you and I are probably already thinking of, if we were defending such a claim, which cases are we citing to that would be favorable to our position, attacking the reliance angle? It is a defensible claim, but does it open the door to a claim? Yeah, quite possibly.
Yeah, absolutely. It opens the door, and you just don't want to have that door open. So you want to be working on some other language in the report to try to prevent that door from being open, so you don't have a claim that you got to get defended on.
So Tina asked a question. I thought that was the last question, but since Tina asked a good question relative to this topic, and I didn't mean to blow everybody up on this, but
Yes,
I'm
you
going to
did.
be doing some podcasts on the new URAR very, very soon and giving you more information. But guys, the data's out. You can look for yourself, start educating yourself, because this train, I'm promising, it's not the express train. It's been a slow moving train, but nevertheless, it's finally getting here. Tina says, can we say no to broadband access and comment that we were told there is X service, but we are not professional IT technicians to verify?
It doesn't seem like Freddie or Fannie are going to want that that version.
Yeah, it doesn't. That sounds like kind of you're trying to sidestep, Tina. And I don't blame you. I understand why you're trying to sidestep, but I think they're going to want a yes or a no, not a no, and give an answer. And a lot of the parts of the country, you can verify that probably pretty easy, but in certain parts of the country, it may be indeed a challenge. Peter Christensen, Craig Capilla, thank you guys very much for joining me today. It's been a long time since we've had a conversation with the attorneys, so I'm glad you guys carved out some time from your busy schedule to do so. Peter, if you're in Vegas, I'm bringing this book. You're going to sign it. If somebody wants to reach out to you and have a conversation, I know, Peter, you're have a new job now, but how can they reach out to you to say hello if they would like to engage with you, Peter?
Well, despite having a new job, I am still open to talking with appraisers, other appraisers that don't work for the company I work for. That's perfectly fine. Peter@valuationlegal.com. And at that web address, valuationlegal.com, I do have a lot of materials about the kinds of things we were talking about today, including the language that Craig mentioned.
Great.
Yeah, I would encourage everybody, if you've not been to Peter's website with all of that stuff, similar to the book, I mean, you really ought to do yourself the favor, do yourself the service of going and checking that out. Now, Brian, to your question, for folks looking how they can get in touch with me, law firm is Franklin, Greenswag, Channon, and Capilla. We're here in the north suburbs of Chicago. And so if you go to fgcclaw.com, you can find my email, you can find my phone number on there, and we're always happy to be a resource if we can help or get you just pointed in the right direction. Please don't hesitate to reach out.
Thank you guys very much. Patricia, to answer your question, it's Appendix F-1 called URAR Reference Guide. Appendix F-1 URAR, a reference guide. You can find that on Fannie or Freddie's website. Jim Morrison, anything in final? When are you heading to Vegas?
I'm heading to Vegas tomorrow, and I'll come on screen. I'm getting ready to go. I haven't done my hair or anything, but yeah, I'm headed to Vegas tomorrow. I hope to see everybody out in Las Vegas for Appraisal Summit. You can still sign up on site if you want to have conversations with these people. Come on out to Vegas and join us.
Yeah. Open invite. You guys come on out. Even if you don't come for a day or two. Jim, your hair looks fine. At least you didn't have a cold shower this morning. Ladies and gentlemen, you've been watching the Appraisal Report webinar brought to you by the very fine folks over at Appraiser eLearning. You need some education? Check us out at appraiserelearning.com. Until next time, happy appraising. Make some money. Take a break. Come on out to Vegas. The flights are cheap. Maybe you'll win some money. For Craig Capilla, Peter Christensen, and Jim Morrison, I'm your host, Brian Reynolds. Until next time, happy appraising.